Welcome to Canadian Justice. I'm Christine Van Gyn. Today we're chatting with author and professor Julie Macfarlane about her book, Going Public, A Survivor's Journey from Grief to Action. The book is more than a memoir. It combines Professor Macfarlane's lived experience as a victim of sexual abuse with decades of legal training to create a course for change. The book offers incredibly valuable insight into what the experience of going public is like for victims of abuse and the institutional forces they are up against. In Professor Macfarlane's case, a part of her journey was her successful civil suit against the Anglican Church, the criminal trial of her abuser, and advocating for change within the church in how they deal with sexual abuse claims. We'll also discuss Professor Macfarlane's campaign, Can't Buy My Silence, which advocates for reforms in how non-disclosure agreements are used in abuse and harassment cases. Today's episode does deal with sexual abuse and trauma, so please use your discretion in watching this episode. Professor Macfarlane, thank you so much for joining me today. Your story in your book is really incredible. I read it on a flight and I couldn't put it down. Let's start with, what do you want people to know about your story?
Well, thank you, Christine, and thank you for inviting me. The reason that I wrote the book, and it took me many, many years to do, it was a long time in my head, in my planning, was because I felt that I had, as someone who'd already published quite widely, a little bit of a platform and an opportunity, but also perhaps even a responsibility to talk about what had happened to me and the sexual violence that I had experienced in my life, because I want to be able to explain to people that this is so common, so pervasive. I hate to say it, Christine, but so normal for people to have some of these experiences. And I think that we have at the moment a very big societal taboo still, no matter what the progress is from Me Too, of talking about this. And so I figured I would be, if you like, an open book for people. And I would try to get rid of at least one of the myths, which is that there are only certain kinds of people who experience sexual abuse or sexual violence. I'm the same person now as I was when I was younger, when I went through these experiences, and they are unfortunately extremely pervasive.
One of the things that stood out to me in your book was the number of times, separate occasions, you experienced sexual violence, starting quite young at 4 years old. Now, anecdotally, this is consistent with what I have seen in my life. Someone who was victimized once, especially early, seems to be more likely to be victimized again. Is there any data about that, and what explains it?
Yeah, there absolutely is, Christine. And, one of the things that was remarkable and very cathartic for me when I wrote the book was that, like you, I had been aware that there was perhaps some data that showed that people who were abused at an early age then suffered reoccurrences of this. So, writing the book was a good excuse to actually spend some time going and looking at that data and to read it. And it's exactly as you say, there is a correlation. The younger that somebody is when they have their first experience of abuse or rape, as it was in my case, the more likely it appears to be empirically that they will have further episodes in which this happens. And so, of course, this meant I had to really kind of look into myself and ask myself why this had happened. And the rationale that the research provides is that people become increasingly broken down in terms of where their lines of what normal behavior will be around sexuality or physical abuse. And that, once those lines have been crossed, no matter how much the victim might be revolted and terrified by this, because it's happened once, it is more likely that the line can get crossed again. And I think that for me, it was a series of kind of breaking down of at 4 years old, I barely had any, normative principles for how, I related physically to other people anyway. And I think each thing that happened then in my teens, when I was abused by the minister, I was then raped at university, and then I was in a very violent domestic relationship for 18 months. And I think by that last one, I had really got to the point that this was almost normal for me
So
to be
terrible.
in this trauma.
So
Yes.
awful. We've got to go to break, but I want to continue this conversation when we come back. Welcome back to Canadian Justice, where we're discussing author and Professor Julie Macfarlane's book, Going Public, which deals with sexual abuse. I advise viewers to use their discretion in this episode, which may deal with topics that are distressing for some people who live with trauma. Professor Macfarlane, one of the other things that stood out to me in your book was there were a number of incidences where you tried to come forward to friends or even colleagues to talk about your experience with abuse, to try and open up in a small way. And many of these conversations did not seem to go well. It seemed like a lot of people were uncomfortable hearing about what had happened to you or talking about it. People seemed to freeze up or brush it off completely.
Change the subject.
Yeah. So I wanted to ask your advice. If someone comes to one of our viewers to disclose an experience of sexual abuse, what is a supportive way that they can react?
Well, first of all, listen to them and appreciate how much time and agony has gone into the decision to talk to you. In fact, I would say that if someone's coming to disclose something like this to you, you should actually feel that you are being given an honor as well as a responsibility, because you're seen as someone that they can speak to. But you have to be aware of how difficult it is to have that conversation, and it might take place in snatches. So, for example, the people that I gradually began to talk to about this only heard little pieces to begin with. And at the same time, Christine, somebody opening up like this doesn't want to get interrogated. So I think that it's important to be mindful of, please come back and talk more to me about this. I'm not going to press you for more information now, but I'm going to go on this journey with you and listen to what you're telling me.
Wonderful advice. Now, one of the things in your book you write about is your successful civil lawsuit against the Anglican Church for abuse you had experienced as a teen from a minister in that church. Now, can you tell me how you came to the decision to sue the church, and what can you tell me about the lawsuit?
Well, it was a very difficult decision for me. This was really interesting because I have my whole professional life studied legal practice, studied litigation, and concluded that it's really not a very good thing for most of us. And it's not a particularly good way of solving problems. So it was incredibly counterintuitive for me to do this. But my lawyer, David Greenwood, who is a remarkable advocate for victims of clerical abuse, he persuaded me that because of my position as a law professor, my relatively public profile, that this would be something that would really help other victims to come forward because it would be reported. I was very clear right from the very beginning that, I didn't want any kind of, I wasn't signing an NDA. There was going to be no publication ban. And so he persuaded me basically that this would be empowering for other people. And so that was frankly, Christine, why I did it. I didn't particularly relish it. And of course, what happened was exactly what I knew from my years and years of study would happen, which is the church just stonewalled me and didn't want to have anything to do with me. So in fact, what I did in the end, because it was so frustrating finding all these things, these bad things that I knew would happen, started to happen. So, for example, I received the statement of defense, which said that as a vulnerable teenager, I apparently had consented to my minister sexually abusing me, which was incredibly distressing and unfortunately very typical in defense statements. But it made me so mad that I wrote a column for the Church Times, which is the world newspaper of the Anglican Church, calling out the church on the fact that they'd just done this to me and saying, if I want to talk about this, I want to settle this case, we don't need to go to court. And surprise, surprise, by the following Monday, the church was in touch and we were going to negotiation.
So amazing what a little bit of media attention will do. I want to talk...
And a little bit of anger.
Yeah, seriously. One of the things that is really important to understand is, in the context of a pastoral relationship, the idea of consent is not a straightforward one. Now, in your story, you were very young and inexperienced teenager, and you'd gone to your minister for spiritual counsel. I think in that context, I think maybe it's easier for viewers to understand why that was not consensual. But I think it's important to understand, even among experienced adults, there can be a fiduciary relationship between a minister or priest and a congregant. We've got to go to commercial break, but when we come back, I want to talk about that fiduciary concept and the notion of consent. Welcome back to Canadian Justice, where we are discussing sexual abuse with professor and author Julie Macfarlane. Just viewer discretion is advised because we are discussing sexual-based violence in this episode. Professor Macfarlane, on the last segment, I asked you about this fiduciary relationship that can exist between a pastor, priest, minister, and a congregant, especially when they are seeking spiritual counseling. What do people know about what that relationship means and how it complicates the notion of consent?
Well, I think that most people would understand that a minister, if you're a member of a church, is going to be a very important authority figure for you. And certainly that was the case for me at that age, but it's also the case, of course, for people who continue to attend churches. And people often turn, as we know, to their priests or their ministers when they are in a crisis. They go there because they're in a crisis and they are vulnerable. And it is shocking to me how many times I have heard, because I hear a lot from survivors of clerical abuse, how many times I have heard from women who are grown women, they are often married women, they've gone to their minister as an authority figure because of some crisis they're experiencing in their lives, and then they are preyed on sexually. And I think that it's important that people understand that that is a complete aberration of what this relationship is supposed to be. It's supposed to be a trusting, confidential relationship. Obviously, when people go to a professional counselor or a therapist, they don't expect to get raped by them. And I think that one of the things that we have to put into this notion of consent to really understand what's going on is the relative power of the parties. And I know that for me, at that age, given that this was my minister who was abusing me, there was absolutely no way I could tell anyone because I didn't think I'd be believed. And I believe that that is the same even today for grown women who have experienced this kind of sexual assault when they have gone and reached out for help from their ministers.
Now, in your case, ultimately, criminal charges were also brought against this particular minister.
Yeah.
And you also were not the only person that he victimized. So what can you tell me about the criminal case?
Well, this was where it became even more surreal for me as a law professor. After I had done the civil case, another victim of the same minister came forward. She had read about my case. She had seen, media coverage about it. And she went to the local police and reported basically exactly the same events with the same person also many decades before. And so the police came back to me and said that they now wanted to prosecute because they had two complainants, two same fact complainants. The minister was in Australia. Probably not a coincidence. And he was then the first minister to be extradited from Australia for historic sex offenses to the United Kingdom. And he went to trial. Obviously, myself and the other complainant could not meet. We couldn't discuss with one another anything about what we were saying. All I knew was that it was from very much the same era, the same years that I had been assaulted by the same person. The trial in the first instance was a hung jury. These are very, very difficult cases for juries, and I'm sure that it was very upsetting for members of the jury to hear some of the evidence that I gave and my co-complainant. It was brought back again a second time, and he was convicted and imprisoned as a result. The experience of testifying in a criminal trial is extraordinary. And even as somebody who is so used to public speaking and knew what that process would be like, I cannot really describe it as anything other than a battering when it came to defense cross-examination of me. And that is the kind of obstacle that makes it incredibly difficult for people to come forward and tell their stories.
One of the things that fascinated me about your civil case was that you were not just merely seeking monetary damages, which is important. It helps victims get back on their feet. But you also wanted systemic changes in how the church handled sexual abuse claims going forward. There were a number of things that you were distressed at, obviously, that you talked about, the claims in the statement of defense about consent, the use of limitation periods to try and bar claims, the forcing out of some churches of victims and complainants once they came forward with their claim. Ultimately, the church did appear to accept a number of your requests and demands as part of that settlement process. We've got to go to commercial break. But when we come back, I want to talk about those systemic changes you advocated for. Welcome back to Canadian Justice, where we're talking to Professor Julie Macfarlane about her book, Going Public, which deals with sexual abuse and violence. Professor Macfarlane, I wanted you to quickly describe the systemic changes that you had asked for as part of your settlement with the Anglican Church and how they deal with abuse claims. What can you tell me about that?
What I negotiated as really a very significant part of my settlement with them was a new complaints procedure for victims who go to the insurance company for the church. And some of the most important features of that were that they would no longer force NDAs on people, non-disclosure agreements, that they would not use this bogus notion of consent, where clearly there was a power relationship between a minister and a congregant, and that would be factors in. And also something very practical, which is that people who made a complaint must be permitted to continue to go to attend to their churches, which is their own community, and they need to be able to be part of that community still.
Really a unique type of settlement. Your reference to the NDAs here, non-disclosure agreements, relates to another thing you wrote about in your book, which is an experience as a professor at Windsor Law School where you were approached by students who alleged inappropriate behavior by a tenured professor at that university. After an investigation, that prof was ultimately fired for cause, but given a reference letter and an NDA, which allowed him to be hired at another school. It's a phenomenon you've called passing the trash. So why would the school agree to an NDA, and what should have been done instead?
Well, what the University of Windsor did in this case, Christine, to be fair, is what universities all over are doing. It's not just the University of Windsor. But what happens very typically is that the university does not want to take responsibility for the fact that they have had, past tense, a sexual predator as a member of their faculty. They feel that looks bad. And of course, what really is the problem is that usually it's been going on, as it had been in this case, for years and years and years, and no one had done anything about it. If they were quicker to react, then maybe there wouldn't be quite so much shame associated with it. So it is both in the employer's interest to cover it up and in the interest, obviously, of the perpetrator. And so that made sense for them and aligned their interests.
So
but not for the people who are going to be taught again by the same professor.
Exactly. And that was part of the issue. You were called by another university that was considering hiring this professor, and you told that university he'd been fired for cause. He then sued you for defamation. So how do you defend a defamation case when truth is an absolute defense, but the truth is hidden behind an NDA?
Well, the answer to that question, Christine, is you can't. The University of Windsor refused to deliver up the documents, the NDA, the letter of termination, that would show that I was telling the truth. And because he sued me in another jurisdiction in Trinidad, I couldn't subpoena anyone from the university to come and give that evidence. So basically, no evidence was submitted and the case was thrown. And I now have a defamation order against me in Trinidad, somewhat ironically, for having told the truth. And I'm now campaigning, along with Zelda Perkins in Can't Buy My Silence, to stop the misuse of non-disclosure agreements in circumstances like these, but also going more broadly. And actually, in the United Kingdom now, we have over 80 universities who have signed up to our pledge not to use non-disclosure agreements in cases of misconduct such as this one.
Yeah, we've only got about 40 seconds left. What can you tell me about that campaign, Can't Buy My Silence? What exactly do you want to achieve with that?
What we want is legislative change, because even a voluntary change like the one I negotiated with the church isn't really going to stick unless we can really monitor it. So we have already brought forward legislation with lawmakers in Ireland, and that then was brought forward in Prince Edward Island. And some of your viewers might remember, Christine, that was passed at the end of last year. And that's a law that will prohibit the use of non-disclosure agreements where they can cause harm to other people, when they're not fully understood by the complainant, and where the complainant isn't asking for it. So it will take it off the table in the bargaining process. That bill is now coming up for second reading in both Manitoba and Nova Scotia in the next couple of weeks. And we hope eventually that all of Canada and all Canadians will be protected from NDAs.
That's all the time we have, Professor Macfarlane. Thank you so much.
Thank you.
We've heard today from Professor Julie Macfarlane and her incredible story of abuse, recovery, resilience, and the struggles of going public and advocating for change. I hope today's story shed some light on the experience of abuse victims and what makes it hard for them to do what Julie did, go public. Thanks for watching, and remember, a freer Canada starts with you.